Hello and welcome to Salon Talks. I'm Andrew O'Hare, the executive editor of Salon. Joining me today is Harvard Law professor Lawrence Lessig, the co-author of a new book with a very provocative title, How to Steal a Presidential Election. Welcome, Larry.
Thanks for having me, Andrew.
We're recording this in the immediate aftermath of the New Hampshire primary, and you and your co-author Matthew Seligman, also a law professor, have throughout the book been careful to identify a MAGA Republican, more or less unnamed, as the principal threat in 2024. I think we now know who the 2024 Republican nominee is going to be. Does this raise the danger of an attempt to steal this coming presidential election?
Yeah, I mean, writing this book was a little bit of a gamble because things could have resolved in a sane and normal way, but unfortunately they haven't. And I think that it's clear that barring some extraordinary event, Donald Trump will be the nominee. And it's clear he's even more extreme now than he was 3 years ago in his willingness to push as hard as it takes to regain power. So I think the concerns we were thinking about when we began writing this book have become even more pressing today.
You and Professor Seligman outline 7 specific ways that hypothetically an election could be stolen or the steal could be attempted. And I certainly do want to talk about those specifics, but I feel like there's a political question overarching this, which is whether the law can actually stop a party, a leader, a political movement who have consistently refused to play by the rules or to observe the rule of law.
Yeah, I mean, in the current political and media context, I think there's a real risk they get away with it. I mean, the media context is extremely important. We today have as many people who believe the election was stolen in 2020 as believed it was stolen on January 6th, 2021. Even though we have a free society, we have free press, we have access to more information than humans have ever had access to, still—
For better or worse.
Yeah, the view is sustained. So the point is that in a world where the public can't be brought around to the truth, it's easy for either side to play games and get away with it because denialism will reinforce itself, especially in the light of the most extreme actions taken.
As a journalist who's worked primarily on the internet for more than 25 years now, I'm well aware of the danger you're talking about. There is another sort of large political or even philosophical question which is sort of haunting all of us and the things you're talking about. Can you really blame people who feel cynical or disillusioned about democracy in a world where the Citizens United decision, the Federalist Society, and the Electoral College and gerrymandering in state after state after state have produced profoundly anti-democratic results?
That is such a great question, and I think it is so true. I find these populist urges sometimes boiling up, and what they want to scream is, what do you expect? What do you expect when you consistently produce a system which is not trusted because it's not trustworthy? When you have systems people look at that constantly benefit the insiders or people with money and don't serve the people democracy is supposed to serve, namely the people. So what's so frustrating to me, and I've been in this fight now for 18 years to stand up political reform that could actually have teeth, what's frustrating to me is that the insiders are willing to play the game imagining that none of these realities are there because they have no capacity to fix it. I mean, Congress itself is completely incapable of standing up the reform effort to tackle some of these issues. And so this is the most terrifying reality, that we continue to spin in this direction of really hopelessness for most people about democracy, and that means the hollowed out institutions of democracy can do even more extreme and outrageous things without any political check.
To be clear, I believe that people should vote, but in the context of, New York Times recently reported, or the Post, I don't remember, that, the election will be decided by about 6 states in which approximately 1/5 of the population lives. And within those 6 states, it's probably 60,000 to 100,000 voters will determine the outcome. And so when I talk to regular people in the world and they say, why should I vote? It doesn't make any difference. I don't really feel like I have a compelling counter argument.
Yeah, so we have, one of our chapters talks about the idea of a legislature just canceling its election, which of course, the founding, there were many states that didn't have an election. They just had the electors selected by the state legislatures. But when you say that today, people are like, oh, that's outrageous. They would never cancel the election. But the reality is, for all but 8 or 9 states in America, the choice the legislature makes to allocate electors, all electors, to the winner of the popular vote in that state is a choice to cancel the election. I mean, no matter what happens, Kentucky is going to go red and California is going to go blue. So why do we actually have to have an election to determine that? But the reality that Kentucky is only going to go red and California is going to go blue is because they've decided to say, if you get a majority, even a plurality of the vote, you get all of the electors. I mean, in 1992, Clinton got something like 37% of the vote in Nevada, but got all of the electors of Nevada.
Because of Ross Perot, right?
Because of Ross Perot.
Yeah.
But so the point is that we already have a system that basically disenfranchises the vast majority of Americans from having any role in the election, and it doesn't have to be like that. I mean, for example, if states allocated their electoral votes proportionally in a fractional way, so if you got 42% of the vote, you got exactly 42% of the electors, then every single voter in America would matter. Every single state would matter. Candidates would care about California and Kentucky and Wyoming and Utah just as much as they care about Pennsylvania or Florida. But it's a political choice, unchecked by the courts. I mean, I tried to stand up a challenge under the Equal Protection Clause to try to get the court to finally say that this is crazy, invalid way of disenfranchising Americans, but the court was not yet willing to take that up.
Well, one of the things that you talk about very eloquently in this book is the danger presented by the fact that the Constitution does give state legislatures so much power in determining how elections are conducted and how electors will be awarded. There are other dangers that you see out there, but isn't the threat of state legislatures or state governors going rogue, so to speak, probably the biggest single threat in terms of undermining a fair election?
Yeah, in theory, the rogue governor is extremely dangerous. Although in 2024, it's not clear we have any clear rogue governors we need to worry about.
The 2022, most of those people, if
lost.
Kerry Lake were the governor of Arizona, we'd be thinking differently.
Yeah, that's right. And the Pennsylvania governor would have been very different too. So it's the state legislatures to really worry about. And one of the strategies which didn't exist before, but has been created by the court's decision about whether presidential electors have any right to exercise discretion in how they cast their ballots. Because of that decision, there's a new innovation in election stealing, which we actually think is probably the most dangerous. And that is that though legislatures can't pick a new slate of electors after an election, because the Constitution says Congress gets to decide when the electors are chosen, and Congress has said that's election day. The decision of the Supreme Court makes it possible for a legislature to say, okay, fine, you're the electors, but here's how you must vote. And there's a companion case in that original decision that said that if you don't vote the way you've been told, you can be removed and replaced. So imagine it's a very close election in Pennsylvania, or Georgia is even a better state to talk about. And there's all sorts of claims of fraud and insecurity in the election count. And so the legislature just declares, though Joe Biden looks like the winner according to the count of the votes, we think that's not actually accurate. So yes, there will be Biden electors, but those Biden electors have to vote for Donald Trump. And if they don't vote for Donald Trump, then we have the power to remove them one by one and replace them with electors who do vote for Donald Trump. Now, that loophole was certainly not intended by Elena Kagan when she wrote that opinion.
I bet it wasn't.
I mean, at the end of her opinions, he said, here we the people rule, but this is actually here we the legislature
Almost
rules.
ironic, yeah.
Yeah, and I think we need to recognize this threat and be prepared for it so that we can resist it if in fact it happens.
One of the things in your book that is amusing, and for the most part is probably not intended to be funny, is when you say that in 2020, Republicans took essentially the stupidest possible route with the strategy by, I believe, your former law student John Eastman.
Yeah.
To assume some magical powers for the vice president who gets to just pick the next president according to him. Why was that the stupidest possible strategy?
Well, I met Matt because he reached out to me in like spring of 2020, and he said, here's an article I'm working on that shows how the presidential election could be stolen. And I read it, and it was a completely compelling argument. So I said, let's co-teach a seminar in the fall of 2020 called Hacking the Election. And what we'll do is we'll work through every single strategy and just how risky each strategy is. And we did that. We taught the seminar. The students were amazing. They put together extraordinary research projects on these strategies. And I think 3 or 4 of them were really clear strategies that could have been deployed to steal that election. And of course, none of them were deployed. And so when we got to January 6th, both of us, we spoke to each other before January 6th. We were like, we really dodged a bullet. That was really quite incredible. And then January 6th happened. Yeah. And it was a quote in the book referred to as like a rerun of the a Muppet remake of the Vietnam War, because it was so stupid and tragic at the same time. Hilarious, stupid, and tragic. But nobody could think that would work, because even if you imagined that somehow Pence could have gotten away with it, the idea he would have gotten away with it because thousands of people were literally holding guns to his head is just crazy talk. There's no way the court would have allowed coercion, that kind of coercion, to produce the next president. And that's actually why, not many people agree with me on this, but why I don't really think the president was intending violence to break out like that. I think he was intending to create a situation that would run over a couple of weeks of building pressure, but never violence, so that Congress, in the shadow of that real anxiety, would then begin to find ways to bend the results in the direction that he had them. But the way things blew up, it was awful.
My theory all along has been that what happened on January 6th was an improvised response to the failure of their strategy, rather than anything that was clearly coordinated in advance.
Right.
So just to be clear about John Eastman, President Trump's former lawyer and your former law student, apparently, his argument that the vice president has some magical powers to control the outcome of the election is nonsense, correct?
It's nonsense. Matt and I disagree a little bit about whether it's crazy nonsense. Matt thinks it's completely crazy nonsense. The reality is that there were law review articles out there that pointed to this ambiguous early history right at the founding.
Thomas Jefferson and John Adams, no less.
Right. Yeah. And also history around the 1876 election, where lots of people were talking about the fact that the vice president would have this special power as a way to coerce both sides to the table to settle that election, which was an election that could have brought the republic down.
A complete disaster.
Complete disaster, right? And so, so maybe it's because he's a former student, I'm more forgiving. But, if you're in the middle of like advising the president, you got 3 law review articles on your table and they all say, yes, the vice president has this special magical power, it's easy to believe it because you want to believe it. But the evidence is when you look at it carefully, and Matt has done really great work doing that careful examination, it just doesn't withstand scrutiny, because neither John Adams nor Thomas Jefferson, when they originally ruled in ways that counted electors that in effect turned them into the next president, were counting electors that anybody doubted were the correct electors. I mean, in Thomas Jefferson's case, it was electors from Georgia. They had not signed their certificate on the right line and not in the right place. And so the question was, do you throw Georgia's vote out because they hadn't signed the certificates? But nobody imagined that Georgia had voted for John Adams. That just wasn't,
right, that claim was not made by anyone.
By anybody. And the same thing in John Adams' case, it was Vermont. Vermont was a solidly Federalist state. There was no doubt that Vermont was going for Adams. So they might have fudged the legal niceties a little bit, but nobody believed that this was an assertion of the vice president's power to just decide who the next president would be. So there's no basis for it. And this is one of the strategies which we are the most clear about. There just is no power in the president of the Senate to ignore the joint session and just pick which slate of electors will be counted. It just doesn't exist. And so that route, at least, we think is the safest to just rule off, not only because Kamala Harris is not likely to play that game for Donald Trump, but also because no vice president should have that power.
And to move on to an issue where you're on record as having views, contrary to what the Supreme Court has found on the question of so-called faithless electors. This is an odd one for anybody that has looked into it, because it's pretty clear that the original intention by Alexander Hamilton and others was that the electors would have considerable independence to maybe not vote for anybody they wanted, but to exercise some judgment in terms of the final outcome. And that's pretty much been overwritten now, so that the whole faithless elector thing isn't much of an issue. Is that correct?
Well, that's right. Although I think it is really still a very important issue. But you're right about the framing context. It's not just that Alexander Hamilton had this in his mind. The very first faithless elector, a guy named Sam Miles, chosen to vote for Adams, voting in the end for Jefferson, was a faithless elector that everybody, a lot of people said, this is outrageous. Why does this guy get to vote contrary to how he was chosen to vote? And that happened before the 12th Amendment, the amendment that finally solidified the current structure of the Electoral College, was adopted. And when the 12th Amendment was being considered, people pointed to Sam Miles and said, shouldn't we do something about that problem? And they said, no, that's just what it is to be an elector. We have to trust these electors. Now, the reality is, in the 23,000 votes by electors in the history of our republic, there has never been a single elector even alleged to have cast their vote because of bribes. And only one who ever flipped sides to go for the other side, and that was Sam Miles, the very first one. A bunch of others moved for reasons about political symbolism or whatever, but none of them were actually trying to overturn the result. So our view was electors are actually the safest, most trustworthy institution in our republic, and the framers intended them to have discretion, and the Supreme Court should uphold it. The Supreme Court didn't uphold it. The Supreme Court said legislatures could control them. That's why we have this risk of them telling them how to vote differently. But the remaining problem is, right now, not every state tells electors how they must vote. There's a bunch of states where they're free. And when we were originally thinking about this in 2016, nobody really imagined the coercion that might be that might manifest itself. People might say
the threats of violence.
Threats of violence,
clear.
right?
Yeah.
I mean, look in the last election, you had states like Georgia where it was incredibly impressive that those Republicans withstood the pressure of the president and did the right thing, and that happened all across the country. But electors, if you imagine as an elector, you're being told, if you don't switch your vote and vote for candidate X, your family is not going to be safe. What would they do? So we actually think that even though I opposed and the electors opposed the regulation of how electors vote, we think right now it must happen that states pass laws that control how electors vote. So there's no room for this kind of threat. And there's also a really important loophole they have to fill about what happens if the president dies between the election and the time the electors vote.
Yes, that was an interesting footnote,
But we think that ought to happen right away, so that the risk of coercion is not actually a risk we have to worry about.
Is that the most important reform that you would hope to see? Spell that out again.
As to electors, there are three reforms.
Yeah.
Number one, Congress should say that if a state tells the electors to vote differently after an election, that's not a vote regularly given, and so that votes don't count. So they should remove that incentive right away, number one. Number two, every state that doesn't tell their electors how they must vote should pass a law tomorrow that tells their electors they must vote the way the people vote. And number three, we have to deal with a case where a candidate dies between the election and the time the electors vote. Because under the rules that say you have to follow the law and vote how you've been elected to vote, you could have a candidate die and those electors have no ability to vote for another candidate. So that restriction needs to be conditioned on the candidate surviving. And if the candidate dies, they ought to be free to vote however they want to vote. That was Congress's presumption when they passed the amendments to the 20th Amendment that changed some of the rules for what happens if candidates die. And so I think that's the third. It's not very high probability, but it's a dangerous probability, because this is the one moment where if an assassin took a candidate out, you could flip control of the presidency to the other party, because if the votes disappear, which they would, that means no candidate would get a majority. It would throw it into the House, and the House could vote for a Republican even though the Democrat has been elected.
Two quick ones, inevitably, about topics in the news because you are a law professor, not necessarily in your book. One of them is a softball. Does Donald Trump, or for that matter any other president, have total immunity from alleged crimes committed while in the White House?
No. The idea that we're asking this question is embarrassing. Yes, no, he does not have total immunity.
Then the more complicated one, what about disqualify? Do states have the right or the authority to disqualify him or some other theoretical president from the ballot under the insurrection clause?
This is a little complicated, but I don't think without a statute by Congress, anybody has the right to exclude federal officers, whether it's Congress people or the president, from being candidates. I do think Congress could pass an insurrection law and said that if you engage in insurrection, here's the proof that has to be established, and if that proof is established, then you are disqualified from being a candidate for president or for Congress or any other office. But right now, there is no such statute. So I don't think that this clause, Section 3, is self-executing, which means that it's certainly wrong for a court in Colorado
or the Secretary of State in Maine.
To just throw somebody off the ballot. There's no such authority because that's not the power which the 14th Amendment is creating. The 14th Amendment explicitly says in Section 5 that Congress shall enforce the provisions of this amendment, in ways that Congress judges. Courts have begun to do it themselves, I think appropriately in some cases, but not in all cases. There's a Section 2 that says that if you exclude male citizens from voting through any number of techniques, then the apportionment to your state falls. Now, you could say, well, why shouldn't we go to courts and say that if you disqualify males because they're ex-felons, or you make it harder for males to vote because you have registration requirements, your apportionment should fall? And many people have tried to do that, and the courts have consistently said, this is not self-executing. Congress has to pass a rule, and we will enforce the rule. And I think that's the same with Section 3.
Very good. Thank you so much for joining us. Harvard Law Professor Lawrence Lessig, the co-author of How to Steal a Presidential Election, outlining 7 ways that we hope it doesn't happen.
Yes.
Thank you so much.
Thank you, Andrew.